This is the voiceover for the Water Rights PowerPoint. Water rights is probably the most complicated thing that we'll learn in the entire course, which is why this PowerPoint voiceover is going to be just a little bit longer. Water rights are very different in California than they are anywhere else in the United States. They follow what's called a plural system of water rights, and it's unique across the United States. You won't find it anywhere else. And a plural system means that there's two different systems, basically. But there are some general principles. There's the public trust doctrine, which we really haven't talked about before. And what it means is that the government holds certain things in trust for the people. One of those would be air. Another one would be water. And that is actually a Roman doctrine, but it was expanded in the United States in 1971 to include wildlife, habitat, and recreation, or more environmental concerns. It's also a usufructuary right, which means it's a property right, but you don't really own it. That sounds strange. And it's part of the California Constitution that all water use must be reasonable and beneficial. It's also the only state with dual rights, which is the plural system, which are riparian and appropriative rights. So what is a water right? Well, it's legal permission to use a reasonable amount of water for a beneficial purpose. You'll notice in this picture, there are miners, and that was considered, and still is actually, a reasonable and beneficial use as long as it's done within certain parameters. So agriculture, urban water use, mining, all of those are beneficial as long as the water use is reasonable. Do you always need a water right? Yes, with one exception, which is a pre-1914 right. And why? Well, because water is part of the public trust doctrine, and it's protected for the use and benefit of all Californians. The public trust doctrine in itself is an interesting legal concept that isn't part of this discussion, but you might enjoy looking at differently. The State Water Resources Control Board administers water rights for the state of California, and they do that through an extensive permitting process. The benefits are that there's protection for everyone, so other water rights users and the environment. Remember that those are co-equal goals. People and the environment are co-equal. And it's important to remember also that many eastern states have no water right laws at all. And that's because they have an abundance of water. The scarcer the resource, the more rights and laws you're going to have around it. So water rights really follow a hierarchy, and this is how the hierarchy kind of goes, but it's not set in stone. So the top of the list is federal rights, which makes sense, right? But really, Pueblo right is overall the one that seems to have more sway in California. There's riparian rights, appropriative rights, prescriptive rights, and groundwater rights as well. And we're going to talk about all of those. And the picture that you see is hydraulicking. That's how they used to mine for water or mine for gold in the Sacramento area by shooting water cannons at mountains and taking down whole mountains. Federal rights. So they apply to the things that you would think, like national parks, Indian and military reservations, national forests, national monuments. And in 1908, it was established by the Supreme Court that they're implicitly reserved, which means that even if there is nothing said about it in a water contract, for example, it's just an automatic that federal rights are going to be there. Most of these groups have had their rights held intact, with the exception of Indians or Native Americans. They're still fighting to get their water rights back, and there have been some very important court cases within the last 2 years, primarily centered around the Coachella Valley, that gave the Indians their water rights back. They've really suffered from a lack of water rights. So this is something that's being corrected slowly by the courts. So the most interesting water right, I think, is the Pueblo right, which is a state right. And we didn't go through this in depth, but when the United States got California in the Treaty of Guadalupe Hidalgo in 1848, they inherited the Spanish right. So the Spanish right went to the Mexicans when they took over California, and then that was brought into the United States, and it's the only state that has that. And what it means is the village has the right to both surface and groundwater to fulfill its needs. Now, that's a really important concept. It's both surface water and groundwater. Most water rights are either surface or ground, not both. And Pueblo rights are generally superior to every other right. Even though federal rights are supposed to be, they aren't really practically. Another important concept is they cannot be lost by lack of interest or use. You'll find that a lot of water rights can be. If you don't use it, you lose it. And Los Angeles and San Diego are the only places that have true Pueblo rights. The fountain on the top is at the Pueblo in downtown Los Angeles. That was the idea for one of your field trips. That little fountain is essentially the foundation for all water rights within the city of Los Angeles. As the city grew, so did both the surface and groundwater right. It's well worth going to see. And the picture on the bottom is actually one of the entrances to the Pueblo, which is quite small, actually. There's a church there on the corner. But Pueblo rights are very, very interesting, and they are the foundation for all of Los Angeles. The next right is riparian rights. Now, Pueblo rights were passed in 1848, and they have to do with both ground and surface water rights. But California became a state, and the state legislature passed riparian rights in 1850. And this automatically caused a problem because Pueblo rights and riparian rights really are at odds with one another. A riparian right works really well on the East Coast where you have a lot of water because it has to do with surface water, but it doesn't work as well in California where surface water comes and goes. We have very few streams or rivers that are wet year-round, especially now. So it's part of English common law, which makes sense because people on the East Coast were from England. And what it is it's surface water, and any area where water naturally touches land has a right to that water. Now, you don't have to use it, but it's considered part and parcel of the land. So if you buy a house on a stream, you automatically have that water right. Whether you use it or not, if you're touching the stream, you're going to have that right. It is generally a superior right, but not necessarily to prior appropriators, which we'll talk about in a minute, and certainly not to Pueblo rights. All riparians are considered related or one family. So that means that if you buy a house and your neighbor buys a house and there's a water shortage, you share in the shortage as well as share in the abundance in a wet year. It's always going to be an equal divider. And it does require permits, licenses, or government approval to draw water. So you can't just automatically do it. The reason for that is how are they going to know that you're sharing in a time of shortage? Appropriative rights came along in 1851, and they're divided into pre and post 1914 rights. Pre being a senior right, junior being, or post being a junior right. And the way that they are permitted by the State Water Resources Control Board is by pre and post. If you're pre 1914, you don't even need a permit. And there are a lot of water companies, believe it or not, that have pre-1914 appropriative rights, but they bear no relationship to the land whatsoever. They are miners' rights. That means that as you see in the picture, there's a sluice box there in the front. They're pulling water from some distant water source, and they're mining. So it's not physically tied to touching the water, but you do have to continually use it. And I missed one there. You must have physical control of the water. You can't just let it run pell-mell. You can't just open up the ditch and let it go. And it has to be a beneficial use, which mining was considered beneficial use. It relates to the date of first beneficial use and volume. So if these lovely miners, for example, in 1902 started using the water and they used an acre foot every month, that would be the volume that was established for their use. because again, it relates to the date of first beneficial use and the volume. So they're called miner's rights because they're first in time, first in right. So a miner who put his X on a tree and marked the spot where he was taking water in 1862 would have a better right than somebody who did it in 1863. And they would also be a pre-1914 or senior water right holder and not even basically need a permit. Now there's prescriptive rights, which are the ones that it's a little bit harder for people to understand. They're gained basically illegally. If you trespass on someone's property and you use water without their permission, you are now looking at perfecting what's called perfecting a prescriptive right. But it can only be granted by a court. And you have to have a concept called adverse possession. So to make it work, you have to meet all of the following criteria. It has to be adverse. That means it hurts the person you're stealing the water from. It has to be hostile, which means you know you're doing it. You didn't ask for permission. You just did it. It has to be in the open. It has to be continuous. You can't start and stop. It has to happen for 5 consecutive years, and it has to be against a private water rights holder, not a public entity. But if you can prove those things and you go to court, it's very likely that the court will grant you that water then under the prescriptive rights corollary. Now, groundwater rights are even different. So a Pueblo rights both surface and ground, but the other rights we've talked about, and so are federal rights, but the other rights we've talked about are all surface water rights. But groundwater rights also are important because most of us live on groundwater. It's the workhorse of the industry. So it's basically, if you pull groundwater, you're called an overlier, and it's an overlying groundwater right, very much like riparian rights, only the water is underground. It's attached to the land. It must be used within that basis. And it has to be shared with other overliers, just like riparian rights have to be shared with other riparian right holders. There was no law for 164 years about regulating the amount of groundwater to be used, but it was passed in 2014, and then it began to take effect in 2015. They were passed with 3 groundwater bills, which are mentioned there. You might want to kind of commit those to memory if you're ever going to work in water resource management. And it was called the Sustainable Groundwater Management Act. California was the last Western state to regulate. Even Texas regulated first. And the reason for that is because often overliers, especially in agriculture areas, don't have any idea of how much groundwater they're pumping. Therefore, the state doesn't know how much groundwater they're pumping. So there was a lot of impetus to not pass a Sustainable Groundwater Act, but it finally did get passed. Because when water rights were set up, there wasn't a whole lot of knowledge about groundwater basins and how a stream might feed a basin or a basin might feed a stream. The one exception is water from a subterranean stream flowing in known and definite channels. That means there can basically be a river underground. The Santa Ana River is a good example of that. There's a lot of places where it flows entirely underground. That's an exception to groundwater rights. And it requires local agencies to develop sustainable groundwater management plans. That's just coming due in the next few years. Essentially, pumping was allowed to go unchecked until this year, and still they got it passed, but one of the caveats was that there doesn't really have to be much sustainability for critically overdrafted basins until 2040. A lot of basins, there's 525 in California, are critically overdrafted, but meaning they're taking out way more water than nature can put back in or we can recharge. And that's not even going to be an issue until 2040. The remaining basins, which are not critically overdrafted, they don't have to have a really good solid plan to keep them replenished till 2042. A groundwater right's an appropriative water right. and it extends only to the surplus water not needed by overliers. So that's also first in time, first in right. You always use it or lose it as an appropriative groundwater right. If you stop using, you're not going to have that right anymore. And that's for a specific quantity. Now that appropriative groundwater rights can be exported and used elsewhere. So that means you can pull from a long way away and maybe sell that water to someone else. So just a few caveats here. Is more water appropriated than available? Yeah, absolutely. Seniority really counts. If you're a Pueblo right, a federal right, you have a lot more seniority. If you're a pre-1914 right, you have a lot more seniority. So in times of shortage, you're going to have your water right fulfilled before, say, post-1914. And even that's graduated. And by that, I mean, let's say you have a 1920 right and somebody else has a 1950 right. The 1950 right person is not going to get the same water right as the other one. Unperfected rights may be reduced. That means that if you have not been to court to perfect your adverse possession, the State Water Resources Control Board may reduce your actual allocation. And water rights can be seasonal. That means that maybe one season it's wet one year and it's a great wet winter. You may end up getting more water than you normally would get versus a really dry year. And these often, when we get into these cases, then you may have to start quantifying as best you can. The State Water Resources Control Board is fairly forgiving. They're only starting to tighten those things up now. I've added this recently because it's something that I think is important for people to realize in California. In California, water is a human right, and that was signed into law in 2012 by Jerry Brown Jr. So it's the first state in the nation to actually recognize this. And what that means is over time, water agencies will have to prove affordability. They'll have to provide water to rural areas and disadvantaged communities. In Southern California, we don't realize it much, but in Central California, there's a whole group of communities that actually don't have good drinking water. For whatever reason, it could be cost, it could be contamination, but this Assembly Bill 685 that was signed into law, it's an attempt to right those wrongs so that everybody in California can get safe, reliable drinking water at an affordable price. So in conclusion, water rights here are much more complex than they are anywhere else in the United States. That's why if you're a water lawyer here, there's only a handful of them. They probably keep maybe 20 or 30. They keep all the business basically within themselves because there's so few. Water purveyors exploit these water rights to a large extent. Often water purveyors have multiple rights. They might have overlying groundwater rights. They might have Pueblo rights. They might have riparian rights as well. So they have so many different rights that they can layer up to keep anybody else basically from getting water. I think that's changing over time where people are working more collaboratively. But the interesting thing is, everybody has water, right? Pretty much in Southern California, water flows. For as goofed up as the system is, it actually works pretty well. I hope this helped you. If you have any questions, please give me a call. Oh, I forgot this. Hey, make some money and be a water lawyer.